Hi, I'm Martha Warriner, a California bankruptcy lawyer with over 40 years experience. Welcome to my YouTube channel, Bankruptcy Basics. Today I'm going to talk about those annoying collection calls, when you can ignore them, and what you should tell them if you do talk to them. If you are behind on paying your creditors, you're probably sick and tired of all the calls you get. Sometimes they call you 2 or 3 times a day, or even worse, they've started calling you at work. And if you block the phone number, they'll just use a different one. Is there anything you can do? Once you decide to file bankruptcy, tell them of your decision, and if you have an attorney, give them the attorney's name and phone number. Let your attorney handle the calls. If you don't have an attorney, they will ask you when you plan to file your bankruptcy case. Tell them the approximate time frame, such as within the next 60 days. Usually that will be enough to stop the calls for a while. When you file bankruptcy, an automatic stay goes into effect immediately, and creditors are prohibited from taking any action, including calling you, to collect what you owe them. Once you give them the date of your bankruptcy filing and the case number, the calls should stop. But what if they don't? Any creditor who violates the automatic stay is subject to sanctions, including any attorney's fees and costs that you incur because of the violation. If it happens once, you should probably ignore it. But if it keeps happening, you or your attorney should send them a cease and desist letter advising, not threatening, that if violations continue, you'll seek sanctions against them, including your attorney's fees. The letter should include a short deadline, and if they continue after that date, you or your attorney should file a motion with the bankruptcy court for sanctions. These letters are usually successful in stopping the creditors, but if not, the request to the bankruptcy court for sanctions generally is. The automatic stay also stops all levies and wage garnishments, but you need to let your employer know that you filed bankruptcy so that they will know to stop withholding your wages. Sorry, but if you don't notify your employer and give them your case number, they will probably continue to withhold your wages. And while you will eventually get any wages that were withheld after the bankruptcy was filed, it may take a month or two. And one way or another, of course, your employer is going to find out about your bankruptcy filing. For answer to these and other questions about bankruptcy, check out my other videos right here on Bankruptcy Basics. And remember, this video is for educational purposes only and doesn't constitute legal advice. Every situation is different, so please consult with a qualified bankruptcy attorney in your area for advice specific to your circumstances. If you live in California and you'd like to schedule a free half-hour consultation with me, you can call me at 760-409-7705 or email me at martha@bankruptcysage.com. Thanks for watching. If this video helped clarify dealing with collection calls for you, please give it a thumbs up and subscribe to my channel for more bankruptcy basics. I'll see you in the next video.